Hello guys, welcome to my channel. Our topic for today is law on arrest. Rule 113, rules of court. Okay, let's proceed to section 1, definition of arrest. Arrest is the taking of a person into custody in order that he may be bound to answer for the commission of offense. Arrest, paghuli, pagkuha sa isang tao. Ginagamit lang natin tong arrest pag ang tao ay nakagawa ng isang crime, no? So pag sinabing crime is an act or omission punishable by law. Then section 2, arrest how made. An arrest is made by an actual restraint of a person to be arrested or by his submission to the custody of the person making the arrest. Hindi lang actual na paghuli, pati pagsuko. No violence or unnecessary force shall be used in making an arrest. The person arrested shall not be subjected to a greater restraint than is necessary for his detention. Pag mag-aaresto tayo ng isang tao, walang karahasan, no? Or walang kailangan ng dahas. Maximum tolerance lang dapat. Section 3, duty of arresting officer. It shall be the duty of the officer executing the warrant to arrest the accused and deliver him to the nearest police station or jail without necessary delay. Sa section 3, obligasyon ng officer na dalhin ang naaaresto sa pinakamalapit na police station. At ano naman ang sasapitin ng ating arresting officer kung sakaling mabigo siya na dalhin sa pinakamalapit na police station ang naaresto? Under the revised penal code, he could be liable for the crime of delay in the delivery of the detained person to the proper judicial authority. Section 4, execution of the warrant. The head of the office to whom the warrant of arrest was delivered for execution shall cause the warrant to be executed within 10 days from the receipt. Within 10 days after the expiration of the period, the officer to whom it was assigned for the execution shall make a report to the judge who issued the warrant. In case his failure to execute a warrant, he shall state the reason therefor. So guys, linawin ko lang dito sa section 4. Ang warrant of arrest, walang expiration yan. Ang meron lang expiration is search warrant. Dito sa sinasabi sa section 4, yung 10 days expiration ng period. After 10 days, magre-report sa judge ang ating arresting officer at magpapaliwanag kung bakit hindi na aresto yung taong nasa search warrant. Under the revised penal code guys, meron tayong tinatawag na reglementary period. Ang code namin dyan, 12-18-36, 12 light offense, 18 less grave, and yung last yung 36 yung grave offense. Kung alin man dito, 12-18-36, whether light offense, less grave, or grave offense, dapat makafile na ng kaso yung na-arresto natin. We go now to section 5, arrest without warrant when lawful. A peace officer or private person may, without a warrant, arrest or a person. Dito guys sa section 5, ito lang yung mga exception sa pag-aresto ng walang warrant. Paragraph A, when in his presence the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Itong paragraph A, dito mapasok yung tinatawag naming doctrine na in flagrante delicto. Yung tawagin naman ay caught in the act. Paragraph B, when an offense has just been committed and he has a probable cause to believe based on personal knowledge of fact or circumstances that the person to be arrested has committed it and naganap or nangyayari, hindi kaya probable cause. When you say probable cause, it refers to such facts or personal knowledge. Pag sinabi naman natin personal knowledge, ito yung sinasabi natin na from the first-hand observation. Paragraph C, when the person to be arrested is a prisoner who has escaped from a penal establishment or a place where he is serving final judgment or is temporarily confined while his case is pending or has escaped while being transferred from one confinement to another. Dito sa letter C, ito yung mga detainee o di kaya prisoner, no? Pag nakatakas sila, pwede natin silang arrestin kahit wala tayong dalang warrant of arrest dahil takas nga sila eh. Section 6, time of making arrest. An arrest may be made on any day at any time of the day or night. Sa section 6, any day or any night, no? Kahit anong araw naman, di kaya gabi, pag mag-aaresto tayo, Siyempre, hindi naman pwedeng araw lang. Section 7, Method of Arrest by Officer virtue of a warrant. When making arrest by virtue of a warrant, the officer shall inform the person to be arrested of the cause of the arrest and of the fact of the warrant has been issued for his arrest, except when he please or possibly resists before the officer has opportunity to so inform him, or when the giving of such information will imperil the arrest. The officer need not to have the warrant in his possession at the time of the arrest, but after of the arrest, if the person arrested so requires, the warrant shall be shown to him as soon as practicable. Tungkulin ng arresting officer na sabihin sa taong inaaresto ang dahilan ng kanyang pagkahuli. In general, pagka mga aresto ang isang arresting officer, dapat may warrant talaga. There should be a warrant of arrest na dala ng officer pag manghuli. Dito sa nabanggit sa section 7, the officer need not to have the warrant in his possession at the time of the arrest, but after the arrest if the person arrested so requires. For example, yung isang arresting officer nagpapatrol, then nakita niya yung matagal ng suspect na matagal na nagtatago sa batas, inaresto niya. Siyempre, hindi naman niya dala yung warrant nung time na nagpapatrol siya dahil hindi naman niya inaasahan na makikita niya yung suspect. Wala siyang warrant na dala. Then, pagka-aresto niya, at the time na dinala niya sa police station, kung ninais ng suspect na makita yung warrant, at the time na nadala na niya sa nearest police station, di pwede na yung pakita yung warrant. At huwag rin natin kakalimutan yung Miranda rights or yung tinatawag nating Miranda warning. Section 8, Method of arrest by officer without warrant. When making an arrest without warrant, the officer shall inform the person to be arrested of his authority and the cause of the arrest unless the latter is either engaged in the commission of offense, is pursued immediately after its commission has escaped, please, or possibly resist before the person making the arrest has opportunity to so inform, or when giving such information will imperil the arrest. Pag inaresto natin ng isang tao, dapat banggitin natin sa kanila ang dahilan kung bakit natin sila inaaresto at magpakilala tayo bilang alagad ng batas kung ano man member ng agency natin, PNP, NBI, etc. Nabanggit ko na rin yung Miranda rights or Miranda doctrine gaya nabanggit ko sa section 7. And then dito sa section 8, gaya ng method of arrest by officer without warrant, refer ulit tayo dun sa section 5, no? Balik tayo sa section 5. Dun binanggit dun yung kung kailan pwede mag-aresto ang isang tao pag walang warrant. Then let's go to the section 10. Officer may summon assistance. An officer making a lawful arrest may orally summon as many persons as he deemed necessary to assist him in effect the arrest. Every person so summoned by officer shall assist him in effecting the arrest when he can render such assistance without detriment to himself. Pwede magpa-arrest ang ating arresting officer. Dito nabanggit na without detriment to himself. When we say detriment, guys, it means injury or damage. Section 11, right of officer break into building or enclosure. An officer, in order to make an arrest, either by virtue of warrant or without warrant, as provided in section 5, may break into a building or enclosure where the person to be arrested is reasonably believed to be, if he refused admittance thereto after announcing his authority and purpose. Pag hindi pinapasok, pwedeng mag-break in pag kinakailangan. Guys, sa mga raid or minsan sa search warrant pagdating sa mga drug bypass operation ganyan, minsan talagang dumidiretso na sila binibreak in na nila kasi syempre tatakas yan importante dala may warrant, no? Then section 12, right to break out from building or enclosure. Whenever an officer has entered the building or enclosure in accordance with the preceding section, he may break out therefrom necessary to liberate himself. Kung sa section 11, right to break in, itong sa section 12, right to break out naman, no? Pag pumasok siya, hindi na siya makalabas. Then, kung kinakailangan niya sirain yung, halimbawa, pintuan para makalabas, then he can do that. Nabanggit dito na to liberate himself. So, what do you mean by liberate? According to dictionary, Liberate means to free. I will give example, no? Police officers liberate the hostage from their captors. Inuulit ko ha, liberate to free. Section 13. Arrest after escape or rescue. If a person lawfully arrested, escape, is rescued, any person may immediately pursue or retake him without a warrant anytime in a place within the Philippines. Dito sa Section 13 mga bes, kung saan natin makita, halimbawa yung suspect nakita natin sa Laguna, sa Manila yung warrant niya, then doon siya natagpuan sa Laguna, pwede natin siyang dalhin doon sa kung saan yung pinakamalapit na police station. Hindi na natin siya kailangan dalhin pa sa Manila, no? Kahit dyan lang sa Laguna kung saan yung pinakamalapit na lock-up or police station dyan sa atin, pwede doon. Right of attorney or relative to visit person arrested. Any member of the Philippine Bar at the request of the person arrested or another act in his behalf have the right to visit and confirm privately with such person in the jail or any other place of the custody at any hour of the day or night, subject to reasonable regulations. A relative of the person arrested can also be exercised the same right. So kahit sinong abogado na choice ng ating suspect, pati yung mga kamag-anak na pwede siyang dalawin. Dito sa section 14, dyan na mapasok yung mga PAW, o di kaya yung kung sino man yung lawyer na gusto niya, pwede. At pag nag-uusap yung binibisita, yung usapan nila ng abogado, hindi po pwedeng i-record yun ng mga ating law enforcement para magamit na ebidensya kung ano man ang pinag-uusapan nila. Bawal po yun, no? Pasok po yun kung sakali sa wiretapping. Pag ginawa ng arresting officer natin yun or sino mang officer, mababiolate niya yung Republic Act 4200. At the same time, hindi rin naman niya magagamit sa korte yun kahit gamitin niya as evidence kahit na tama na o pagpalagay natin inadmit ng suspect pati kung paano niya ginawa, etc. Hindi tatanggapin sa korte yun. Yun lang guys, salamat sa panonood. Sana may natutunan kayo. Kung may tanong man kayo, i-comment nyo na lang at susubukan ko po sagutin.